Well, good afternoon. I know you've had a stimulating session this morning. You have more this afternoon, and I hope to add to the interest of the day's event. I commend first the League of Women Voters and the other sponsoring organizations for their very good work in bringing to us these timely issues. None more pressing, I might add, than the state of judicial selection in Michigan. In a way, the debate about the selection of Michigan Supreme Court justices is part of a larger national debate over the role of judges, judicial independence, and the public's perception of the judicial system. I believe that in large part, due to the process whereby we choose judges and justices here in Michigan, the public's view of judges and the Michigan Supreme Court has become more negative. As a result, fewer people believe that the state's justice system in general is fair and impartial. It's useful to review at this point some background and history and how they've affected the public's perception of not only the Michigan Supreme Court, but also the public's trust and in the impartiality and fairness of the justice system as a whole. As you know, under the Michigan Constitution, a candidate for the Michigan Supreme Court must be nominated at a party convention, but runs on the nonpartisan section of the ballot. This seemingly inconsistent and much ridiculed arrangement, which is provided for by the Michigan Constitution of 1963, is in fact aimed at improving the quality of candidates for the Supreme Court. The logic is that the political parties will improve and provide some quality control for their nominees and somewhat level the playing field that might otherwise be dominated by wealthy candidates and by well-known names if there were a nominating election. And the political parties have, in my opinion, often done a conscientious job by nominating qualified people. When I ran first for the Court of Appeals back in 1988, that court being nominated not by a political party but by an election, there were 16 running for the nominating election for 2 spots. And I remember thinking to myself, how could the electorate possibly sort us out? And the other candidates they had to deal with for other offices at the same time. Also, you might reflect that although we have an elective system, many Michigan justices and judges arrive at the bench by gubernatorial appointment. And unlike the federal appointment system, in which the president's appointments are subject to the advice and consent of the Senate, the governor in Michigan does not have to seek confirmation from the legislature, and in fact doesn't have to follow any process at all. From 1999 to 2008, 3 justices, my colleagues Robert Young, Stephen Markman, and former Chief Justice Clifford Taylor, were all appointed by former Governor John Engler. Justice Maura Corrigan was elected to the Michigan Supreme Court, but had already served on the Court of Appeals, to which she was appointed by Governor John Engler. Similarly, Governor Granholm has appointed a number of judges to the Michigan Court of Appeals and many to the circuit, district, and probate courts. These appointed justices and judges have then run in the next general election in order to retain their positions. On the ballot, these individuals are designated as incumbents of their courts, in contrast to the other candidates, and as a rule, this gives them a tremendous advantage. Witness the fact that only twice in the history of the state has an incumbent Michigan Supreme Court justice been defeated in an election, and an incumbent Michigan Court of Appeals judge has never been unseated. Now, one might argue it's because they've done such a good job that people simply have been pleased to see who they are by the incumbent label and then voted for them accordingly. But in reality, the truth is, and it's important to take this into consideration, that we have in Michigan, where we think we have an elective system, we have in fact an appointive and an elective system, a mixed system. In terms of campaign contributions, the law limits individuals and PAC contributions to candidates for the Supreme Court and the Court of Appeals to $3,400 per candidate per election cycle. Moreover, although a candidate's election committee cannot solicit contributions of more than $100 from lawyers and lawyers' PACs, individuals and PACs may give more within the $3,400 limit if they choose. Until relatively recently, not a lot of people outside the legal community have focused on most state judicial elections. Michigan Supreme Court elections have been described by the media as sleepy, low-budget affairs. And this could be because the public has not been unhappy with people and simply not been concerned. But certainly there used to be very little advertising for these jobs, apart from some bumper stickers and long signs and campaign mailers, and very little media attention. In fact, as recently as 1994, my colleague Elizabeth Weaver beat 3 male candidates in one re-election to the Michigan Supreme Court while raising all of $187,000. Of course, Justice Weaver by then had campaigned many times in Michigan, been elected, and built a constituent base. In any event, by 1994, the quiescence of these campaigns was about to change. Between 1994 and 2000, Michigan Supreme Court candidates' campaign chests more than quadrupled, from an average of $322,000 in '94 per candidate to $1.14 million in 2000. Now, some of that money came from the candidates themselves, but at least 84% of it came from the political parties and from business, from attorneys, and from labor groups. And of those contributors, many appeared before the court. It's been estimated that between 1990 and 1999, 86% of the Supreme Court, in 86% of the Supreme Court's cases, there were litigants or lawyers who had made a campaign contribution to one or more of the justices. Now, some make a contribution to them all, so they're sure to cover their bases. In which case, of course, no one is favored over another. The 2000 elections, in which former Justices Taylor and Justices Young and Markman were all up for election, reached new heights in spending and marked a new low in terms of contentiousness. A total of between $13 and $15 million was spent by Supreme Court candidates, the Republican and Democratic parties, and outside interest groups. In the last election, former Justice Taylor raised over $1.9 million, while Justice Diane Hathaway had $752,736 in total contributions. The advertising in the last election suggested that, among other things, one of the candidates was soft on terrorists and the other was a spendthrift with taxpayer money.